Hi everyone. Hope you're all going well. I think my internet just cut out and I dropped out of the Zoom and reappeared already during Lisa's introductions, so that's a good start for me. But hopefully the internet stays very stable from here on in. Welcome to today's Child Safe and Member Protection Forum on the topic of exploring best practice privacy management and e-safety in sport. And thanks again for joining us online for another webinar. We had penciled in something face-to-face. Unfortunately, we're back in lockdown with another wet, rainy week. Hopefully our next Child Safe Forum over summer, we'll be able to do face-to-face. My vote is we all go down to Torquay, have the forum and go to the beach all fully vaccinated. So look forward to that one. Vic Sports, we've been working with the sports industry to help create child-safe environments for over probably 5 to 6 years now, since the implementation of the child-safe standards back in 2017. And one of the areas that we've found is quite challenging for a lot of sport organisations is how to manage the privacy of data and information, how to adhere to the relevant sort of laws and policies and rules, especially doing complex child safe or member protection cases, and cases that sometimes involve the police, the courts, multiple authorities or organisations. We know that can be a stress for people to manage. We've also noticed that e-safety has become, of course, quite a significant issue over the past decade as social media becomes a key part of society and of social groups. And the issue of safe online environments and abuse is not something that is going away, and is actually something we need to continue to work on as an industry. The agenda for today, so we've got a few excellent guest speakers. We'll have a very short break in the middle, so you can have a stretch and grab yourself another coffee. And we'll do a panel session and Q&A towards the end of the webinar. Please feel free to post any questions in the Zoom Q&A. We might be able to answer them as we go in the chat. Otherwise, any other questions we can deal with later on during the panel discussion. Great. So without any further ado, I'm going to introduce the first speaker from today. Simon Merritt, who is a senior associate at Lander and Rogers. Simon is a specialist sports lawyer with extensive experience in the sport, leisure, and not-for-profit sectors. Simon advises a variety of the firm's sport and leisure clients, working closely with them to achieve positive outcomes. Simon lives and breathes sport and has a wealth of industry experience as a lawyer, administrator, and athlete. And we've been working closely with Simon over the past 6 years on child safety as well. So welcome to you, Simon.
Thanks, Tom. I'll just bear with me while I share my slides. So thanks everyone for attending the webinar. Thanks Tom, Lisa and Vic Sport for having me. I hope everyone online is surviving lockdown 5. If someone told me 18 months ago that I'd be conducting or presenting at a Vic Sport webinar in my slippers, then I would have laughed at them. But I now know I'm a bit of an avid AFL 360 watcher, and always laughed when I saw Mark Robinson in his suit jacket and shorts under the desk, and I'm now getting to live his experience. So that there you can pick some very minor positives from the lockdown, but I hope everyone's doing okay, and particularly for the parents out there and carers that are homeschooling for the next week or so, all the best. My wife's a primary school teacher, and you may hear her in the background taking some of her classes. So yeah, all the best to everyone that's managing that juggling act. As Tom said, I'm Simon Merritt. I'm a senior associate in the sport and leisure team at Lander and Rogers. we practice and work exclusively in the sport and not-for-profit sectors, so work for a large variety of sporting organisations at the national, state, regional, down to the club and grassroots level. So these topics
looks like we've lost Simon. Oh, he's jumping back in. Something about running webinars, everything IT-wise, internet just starts to fall apart on us. Simon, how you going? Are you back?
Yes, I'm back. Sorry, I'm not sure whether that's me or Sport.
I'm not sure. Everything just disappeared, so that's all good. We'll give you a moment to get everything working again.
Apologies for that. So today we're going to, I'm going to briefly run through basics of the Australian privacy principles as they apply to sport, and then in the second half of the presentation, drill down to how that applies to member protection and child safety issues in sport. This is an area that probably over the last 3 or 4 years post the Royal Commission has become really front of mind for sports, where potentially previously that wasn't the case. And to the extent that sports had privacy queries previously, it was much more focused within the commercial space and how they were able to utilise the information that they collect with sort of the personal information of sports members and its membership database being one of its sort of most valuable commercial commodities. Whereas, as Tom mentioned, with the advent of some new child safety legislation, both in Victoria at the forefront and nationally, the way sports can go about managing the various issues that they have to investigate and potentially sanction individuals and from a privacy, confidentiality, defamation perspective are really now a large part of the drivers behind the advice that sports are seeking in this area. So that's a bit of a roadmap about what we're going to talk about today. It's probably pretty obvious these days why protecting privacy is important from a sports perspective, but really the advent of the new technologies that individuals and particularly children these days are using in their everyday life, and the information and personal information that those technologies, those apps, those games, that e-sport is collecting on a day-to-day and minute-by-minute basis really shows why the collection, storage, and protection of that information is really critical. And sort of I was thinking that the first three sort of privacy issues that came to mind when I was thinking about that were Facebook, Ashley Madison, and PlayStation, which I'm sure a lot of people have heard about, but a simple Google can show you what those issues are about. But the reputational damage that an organisation can experience these days when they have a data breach or a significant privacy issue is really significant, and potentially in the Facebook and Ashley Madison example, they're things that organisations can't necessarily come back from a reputational perspective. So in the sporting industry in particular, where there's new linkages between sports and the technologies that athletes and members and participants are using, sort of thinking of your Fitbits and your GPS technology, Strava and the like, there is a lot more personal information being collected nowadays than previously, even for fairly grassroots sporting organisations. So these are some of the basics that we'll be going over today. Hopefully, or for most of you, the reference to the Australian privacy principles shouldn't be something new. At the outset, I'll touch on that not all organisations that are attending this webinar today will need to legally comply with the Australian privacy principles. There are some qualifying requirements under the Privacy Act, but certainly a lot of the larger state bodies that are here today will absolutely be aware of the Australian privacy principles, which are a schedule to the Privacy Act and the requirements that the sport has to comply with. I'll touch on a few of the key APPs that apply to sports, which are set out on this slide here. And these really include the collection of personal information, how a sport can deal with that information, and how people can access and what sports can do with the personal information that they collect. From an APP or an Australian privacy principle perspective, there are 13 principles that are broken down into the 5 parts listed on the slide there, and we'll go through some of those key ones shortly. So as I was mentioning earlier, anyone representing a grassroots club on this webinar may not be bound by the Australian privacy principles under the Act. The Act refers to APP entities to cover those that need to comply with the Act. From our perspective, we're primarily looking at organisations which are the private non-government entities that need to comply. So as a starting point, an organisation needs to comply unless an exception applies. And for sporting organisations, the most relevant one is what's termed the small business operators that are defined under the Act as any organisation or the bodies covered. So that can include sole traders, trusts as well, that have an annual turnover of 3 million or less for the financial year. So to the extent that grassroots clubs are turning over much less than 3 million, generally, then they're not going to be bound by the Australian privacy principles under the Act, but any private organisation that does meet that threshold will need to comply. Importantly, from a threshold perspective, once an organisation or a business hits that threshold in any financial year, it will need to continue complying even if it subsequently drops below that threshold. So from a sport perspective, we would find that the larger SSAs would generally always need to comply. From a club perspective, there are larger golf clubs, tennis clubs, sailing clubs, and the like that will need to comply. But from a grassroots club perspective, in our experience, it would obviously be very rare for the organisation to have a turnover of more than 3 million. The key concept, or one of the key concepts under the Australian privacy principles and Australia's privacy framework in general, is this term personal information. That's defined under the Act, so broadly speaking, as the dot point sets out, but it primarily deals with any type of information that means a person is reasonably identifiable. So when we think of personal information, generally people will just think of the person's first name and surname, and certainly that will be personal information in almost, if not all cases, but there are a much broader range of personal information that sports regularly deal with. And in the second half of this presentation, we'll touch on how that impacts how sports deal with it. But something as simple as a photo of a person competing in their sport can, in certain circumstances, constitute personal information because the individual will be reasonably identifiable. Within personal information, there's a smaller subset termed sensitive information, and this type of information has additional protections under the Act, and that's because when it was created, the legislation recognised that the type of information that fell within that subset is potentially more important, or something that individuals would ordinarily want a higher amount of protection afforded. And those examples there include types of sensitive information, and from a sport perspective, it's generally health and health-related data and information that will fall within that subset. So it's something that sports who collect that type of information, and in the high performance programs of sports, collection of health information and medical records and the like is a very common occurrence. That's something that sports need to be aware of, because they need to be across the additional protections that that type of information is afforded. There's one major category of exempt information under the Australian privacy principles, and that's employee records, which we'll touch on now. When the Privacy Act was established, there was an intention that the workplace legislation, which is state-based in the various jurisdictions, would cover the protection and collection, protection and use of employee records. This under our federated system hasn't actually been the case, so there's a gap currently there, but ultimately employee records are exempt from the application of the Australian privacy principles. Importantly, employee records does not apply to prospective employees. So these records relate to any individual that an organisation has had an employment relationship with. So unsolicited CVs and applicant CVs are one category where the employee record exemption won't apply. So that information needs to be dealt with in accordance with the Australian privacy principles. And from a sporting perspective, it's important to note that the exemption for employee records only extends to the employment relationship between that employee and a sport. And this is relevant because in many sports, the employees will often be members of the organisation in a separate capacity to their employment. And for that sport, if it's bound by the Australian privacy principles, it needs to deal with the membership information, and that will generally be the same type of information that the sport collects as with any other member. It needs to deal with that type of information in accordance with the privacy principles. So the exemption doesn't apply to the individual, the totality of their dealings with the sport, only their direct employment relationship. So moving on to the APPs, one of the critical requirements is that any APP entity that is subject to the principles needs to have a privacy policy, and it needs to, the Act prescribes the types of information that needs to be included in that policy. And that's the reason why you'll find that for almost every organisation these days, that they try and hide it. At the very bottom of their website, they will have a privacy link where you can click on and read through their policy. And that is a requirement that it's public facing. So individuals who are likely to have their information collected can review the clauses in that. Not that probably anyone ever does, to be honest. The collection of personal information is something that sports need to be really aware of, because, sort of, as I mentioned previously, membership data and the list of members of a sport are firstly one of its most relevant commercial properties, but secondly, it will, as we touch on later in the presentation, directly impact how and to what extent sports can provide information about disciplinary sanctions and member protection matters. But essentially, the APPs provide that the organisation can't collect information unless it's reasonably necessary for its function. So obviously there's no general prohibition on a sport collecting member information, because a sport can't function without being able to administer its membership relationship. But the APPs do make clear the requirements that an organisation must comply with when it does collect information. And one of the most relevant requirements from a collection perspective is what you may colloquially hear referred to as collection notice or a collection statement. And that is an organisation, an APP entity must notify an individual when it collects personal information about them, and the collection notice must include a number of prescribed matters under the APPs. This is really relevant for member protection and child safety topics for a sport, because the point of collection is where a sport sets out why it's collecting the personal information, what it may use the personal information for, and to which third-party entities it may disclose that personal information. So generally speaking, if it's through a membership application, that collection notice will set out that the name, address, email, etc., of the member is being collected for the purposes of administering their membership. But a sport that is an APP entity needs to think very carefully about the variety of uses it will make of members' personal information going forward, because the collection notice is where the organisation can get consent from an individual to those various uses. And as we'll touch on the next slide, that consent is really important, because without consent of individuals, there's only a fairly limited variety of uses a sport can make of personal information. We've included this case in here just sort of mainly to emphasise that sports and sport-related organisations that are APP entities certainly can attract the attention of the Privacy Commissioner from time to time. It's often the case that sports will think that there are bigger fish to fry out there, and that notwithstanding potentially minor non-compliance, then they won't attract the ire of the regulator. But that's certainly not the case as provided by this case, where there was certainly an economic penalty imposed. The relevant sort of legal issues arising from the case was a discussion and an argument on whether the club could rely on one of the defences around disclosure of the information in accordance with the law, and the club wasn't able to make out that defence, hence the sanctions that were imposed. From a commercial sort of rather than member protection and child safety perspective, direct marketing is really relevant to a sport's compliance with the APPs, and that's because there are more strict compliance requirements for an entity to use personal information that it's collected for direct marketing purposes. And the definition of direct marketing is under the Act is it doesn't have a direct definition, but the Privacy Commissioner takes a broad view on what that captures, and it essentially means communications relating to products and services that the organisation provides itself or of the products and services of its sponsors and related parties. So you'll find that if an APP entity is compliant with the APPs and you receive what some people may refer to as spam, but offers or deals from sponsors of the club or the club itself, then to be compliant, then you will have given consent at some point under the privacy collection notice or some form of opt-in through your dealings with the club. And that's also one of the reasons why you'll find an opt-out feature on those types of communications, because the Act is very clear that for direct marketing communications, there must be an opt-out facility provided. And if a person opts out of those communications, then unless there was a subsequent opt-in, then the sport or the APP entity is no longer able to provide those communications. The APPs extend further from how the sport or APP entity can use and disclose the information. There's also requirements around security of information, and certainly going forward, that's probably one of the areas where organisations have the most exposure because of the ability of hackers to access information without authority due to failings of security systems and the like. So certainly cyber insurance is one form of risk management that large organisations with vast arrays of data that they hold are looking to deal with those matters. And certainly I foreshadow at some point that directors of organisations under the Corporations Act may, or under the Privacy Act may in future have personal liability for sort of egregious data privacy breaches. Fairly recently, in legal terms, so probably sort of 3 or 4 or 5 years ago now, there was a one further relevant change to the Privacy Act from a sport and APP entity perspective, and that was the introduction of a mandatory data breach notification scheme. And in short, that was a requirement where if a APP entity became aware that there'd been a breach of personal information that it had collected, then was required to take certain steps to both notify the individuals affected and notify the Privacy Commissioner about it. There's 2 levels under the breach notification regime. That the first one, as stated there, is if there's reasonable grounds to believe that there has been a breach. The second one is where there is not such a high evidentiary possibility of a breach. So it's talking about sort of the suspicion of a breach. And in that secondary scenario, it's a requirement, it's a statutory requirement to conduct an assessment and then decide whether there must be a report. Whereas if there's really strong evidentiary grounds to show that there has been a breach, then there must be a report immediately. So this is going to be relevant from an ongoing perspective for sports that are APP entities where there is a data breach. And as we'll talk about briefly, the concept of a data breach under the legislation comprises a lot more than simply hackers accessing a sports system without authority. Examples that occurred early in the reporting period for the Privacy Commissioner included really simple things such as a work laptop being stolen from an employee's car, or a USB drive being lost or left in a place and therefore unable to be found that held personal information on it. So anything that covers a scenario where that the personal information held by an APP entity may be exposed and serious harm caused to the individuals, certainly gives rise to at least the probability that an APP entity needs to investigate, if not report immediately. So those are the 2 limbs of what is required for an eligible data breach to have occurred. From a sport perspective, it's not necessarily the case that unauthorized access to member database or the CRM is likely to result in a data breach because of the requirement that there has to be serious harm to the individuals concerned. It's probably rare that third parties being able to determine that an individual is a member of a particular sporting organisation or a club or an SSA is likely to cause serious harm. And going by the Privacy Commissioner's advice, there would certainly need to be additional areas where harm could be caused if it was simply the name of an individual linked with being a member of a sport. We can contrast that with the Ashley Madison privacy breach mentioned earlier in the presentation. Obviously, in that scenario, disclosure of a name alone may be enough to meet the hurdle of serious harm, but from a sporting perspective, it's unlikely, and it's more likely than not that other information would be needed. And when looking at whether serious harm has occurred, they can take an aggregated approach. So if it was simply the name of an individual, that may be unlikely. But if you combine the name with their date of birth or other identifiers that increase the likelihood that a third party could impersonate that individual, then you're getting much more towards the stage of serious harm being potentially possible. There's also the exception that an APP entity can take remedial action, and if that action is sufficient to avoid the harm occurring, then an eligible data breach won't have occurred. And potential examples of this, if we go back to the laptop stolen from the car, if the APP entity has the ability to wipe the access to the information, then that's potentially looking towards the remedial action that's going to avoid the APP entity needing to notify. So those are some of the other requirements for data breaches. It's important. The one takeaway from a data breach that you have from this presentation is that the timeliness required. For the secondary limb where there's some mere suspicion that a breach has occurred, the investigation and determination of whether a report is required needs to be undertaken within 30 days. So it's essentially something that needs to be undertaken very promptly, and generally we would always recommend that advice was sought immediately as soon as a sport is aware, if they're an APP entity, is aware that they've suffered a potential data breach. This is a summary of the serious harm concept. It's for sporting organisations, it's probably likely that a range of data breaches are not going to cause serious harm, but to the extent that financial information such as credit card data is included in any breach, then you should take the view that almost automatically serious harm is likely to have occurred. And similarly, where sports collect medical information, then again, if there was a breach that pertained to medical data or medical records, again, the automatic presumption would generally be that serious harm is likely to occur. So those are some of the factors that you would take into account in determining whether serious harm will or is likely to occur. And again, one of the primary results of a data breach, other than the sport or the APP entity having to report to the Privacy Commissioner, is it needs to send a notification statement to all the individuals who have had their personal information affected. And from this perspective, it's not only notifies the individuals, but it has the likelihood of resulting in significant reputational harm, depending on the type of organisation and what the types of data or personal information were that were breached. So from that perspective, the breach regime has included this requirement, I think, potentially from a public policy perspective, to somewhat name and shame organisations by having to disclose to the broader community about the breach and the resulting media and attention that will cause. It's relevant to note for sports that to the extent they engage third-party contractors and service providers for various service provision, that's unlikely to avoid the sport itself being the relevant entity for eligible data breach purposes. So the most common example where a sport engages a IT provider to create or administer or establish the database or member CRM or whatever program is used, to the extent that there was a data breach occurring through a failure of that system, whilst it may constitute a breach of contract between the sport and that service provider, it's still likely that the sport itself will be the relevant entity that has to deal with the data breach. So a reason why any contract with a service provider that is going to touch upon the collection or transfer of personal information absolutely should have some fairly stringent privacy related clauses. And similar obligations apply where personal information is sent overseas, which is obviously a fairly common occurrence where the system is hosted on servers located overseas. And that's just a summary of the requirements for a data breach. But as I said, the key takeaway from that perspective is if a sport considers there's been a breach of its system or there's something that's occurred that is likely to cause personal information that is held by the sport to be accessible to third parties without authorization, then it's highly likely that an investigation, at least as a minimum, will need to take place. There are some fairly stringent consequences of non-compliance under the data breach regime, primarily dealing with this phrase, interference with the privacy of individuals. And certainly the Privacy Commissioner has shown a willingness to litigate and impose enforceable measures for breaches of these provisions. So there's some of the penalties that can apply. So there are very serious or potentially serious consequences where there's a breach and the procedures are not followed. The phrases serious and repeated interferences of privacy aren't defined in the Privacy Act, which is somewhat unhelpful, but they're objective questions that take into account a number of factors, including the individuals involved, whether it was sensitive information, so bringing in those concepts of was it credit card data, was it medical records, the consequences to the individuals affected, whether there's been any group of vulnerable or disadvantaged people affected, and whether it includes deliberate or reckless conduct. So moving on to the application of these concepts to member protection and child safety matters. When a sport will come to us for advice, often in these areas, the question will almost always pertain to, can they disclose either the fact of an investigation or disciplinary procedure being enforced, or can they disclose sanctions imposed on an individual to third parties, whether that's a school or another sporting provider or any third party. Ultimately, privacy and the sports compliance with the Privacy Act is but one of, unfortunately, a number of legal issues that need to be considered when a sport's thinking about, can it disclose those types of matters. Coming back to first principles, sporting relationship with its member is, from a legal perspective, primarily one of contract. The member signs up to be a member of the organisation. It will generally become a member under the organisation's constitution, and therefore the constitution and policies and procedures enacted under it form a contract between the sport and the member. And that's the primary way that a sport will have jurisdiction over a member under the member protection policy, and why the policy is enforceable legally. So when a sport if you're a committee member or a director of an organisation thinking about these issues, the primary and the first point of call is looking at the policy itself and looking at the confidentiality provisions under that document. It's almost certain that the member protection policies of sports will have confidentiality provisions in there. Generally speaking, those will relate to the confidentiality of investigations and the process. What we're seeing in the past couple of years is a move towards having express carve-outs to the confidentiality provisions. 5 years ago, you might see a clause that basically says the entirety of the process is confidential, and it's likely that the sanction may also fall into those provisions. Nowadays, and primarily off the back of the Royal Commission, there's a real want and need for sports to be able to share information about these matters, not only with other sports, but with other organisations. And the Royal Commission certainly took a view that if an entity or an institution was failing to take a step to protect children purely to mitigate or minimise its own risk, it would look very unfavourably on that. So potentially previously sports have chosen not to share this information due to a risk of breaching the policy. So over the past couple of years, we've seen that policies are now being changed to expressly allow sanctions to be publicised to a discrete group of third-party organisations. Defamation, which is obviously very commonly in the news these days, is another fairly complex issue that needs to be taken into account for the sharing of member protection proceedings and sanctions. Unfortunately, from a defamation perspective, it's not necessarily the exact information that is shared that causes the risk. Without going into the definition of defamation, it's not exactly what is said, it's potential imputations arising from what is said. So as a result, if a sport shares information that specifies that a coach or a player has had X sanction, there may be various negative imputations arising from that. Pardon me. It's these imputations that are potentially an issue for the sport because they can be litigated by the person who's suffered the sanction. So as a result, a sport will need to be very careful with what it says when it shares information about a member protection matter, even if it's permitted to under the member protection policy from a confidentiality perspective. The main reason for this is it needs to avoid the coach or player or athlete or person subject to the sanction being able to litigate the sport for defamation. The main ways that we would normally advise a sport to minimise this risk is to firstly stick to the absolute facts of the situation, but secondly, to minimise the type of information provided to the third parties. Pardon me. This allows the sports to rely on a broader range of defences to defamation in case it is litigated. From a privacy perspective, it's probably relatively straightforward around disclosure if the correct privacy collection notices have been provided. So as we discussed previously, the collection notice must set out the ways that the sport will disclose the personal information collected from individuals. So if an APP entity that's a sport has a properly drafted collection notice that will incorporate information about not only the administration of the membership, but a reference to disciplinary proceedings, and the third-party organisations that information is disclosed to will extend to the types of entities that the sport will want to share that or potentially need to share that information with. So just by way of example, it would be very common for that type of collection notice to refer to the other levels of the sport as a minimum. So if it's a state body, then it will refer to the national body, the other state bodies and clubs or regional associations as third parties who the personal information collected may be disclosed to. Sports need to also have a really careful think about the types of third party entities that it would be potentially disclosing this information to. And so from a sport that has a primarily junior membership base, those third parties may range and extend to schools and other caring bodies, whereas an adult focused or more predominantly adult focused sport might not need to extend to those third parties. And obviously, to the extent that a sport is not an APP entity, then generally speaking, most of the privacy law factors when considering disclosure of MPP information falls away. But it's always worth having a think about, is there anything else from a privacy perspective under the contract that has been included? Generally, there won't be, and the pure wording of the member protection policy will cover those matters, but it's a matter of ensuring you read the policy and are aware of what it says in relation to confidentiality and privacy. And similarly, things to think about when a sport is considering, does it share information about sanctions or a person being subject to sanction, is what is the type of information that's being shared and what's the underlying purpose for sharing that information. So by way of example, the fact of a coach or an athlete being suspended is generally speaking the key piece of information, and along with the period of time that they're suspended for or expelled from the date of. It's not necessarily going to be relevant or directly relevant for that purpose to provide any further information to those third parties. And in our experience, it's when potentially unnecessary information is shared where a sport assumes a significantly higher legal risk. The next one is how widely distributed is that information, and really does the recipient have a direct interest in knowing about that information? And then again, touching on what we talked about the Royal Commission, the potentially clashing legal and moral duties of a sporting body. So certainly historically sports have potentially taken the route of minimising their legal risk, which has resulted in this information not being shared. Now, off the back of the Royal Commission, our advice to sports would be that there is just as much, if not more, risk in taking that approach, even if the legal risk was minimised compared to disclosing, because of both the moral and ethical duties of sporting bodies in the member protection and child safety / sports integrity space, and secondly, the reputational damage that can be caused in a scenario where a sport was forced to front some form of Royal Commission to deal with its handling of this type of matter. And certainly we've seen that directly through the sport case studies that were dealt with under that Royal Commission. So that is a real snapshot of the types of legal and legal related matters that a sport needs to consider when it's thinking about sharing the sanction information of its members to third parties. And from our perspective, the first overarching point to make is it certainly can be done where the framework underpinning the disciplinary proceedings allows for it. And secondly, there are absolutely ways that it can be done to minimise the legal risk to the sporting body compared to alternatives where there is going to be significantly higher legal risk. And it's not, in our experience, unfortunately, it's not theoretical legal risk to sports. We've had a number of situations where a sport has had a person who's been sanctioned not just take preliminary, but take further steps to litigate the matter under defamation or a breach of contract in relation to third-party disclosure of sanctions. So something that has to be absolutely front of mind for sports when thinking about that. And further considerations, particularly in the child safety space, when thinking about if a sport is an APP entity, its privacy law obligations is it legally permissible, and if so, is it still ethically okay? And I think so the Privacy Act is currently under a review, and one of the things that is being considered is whether there should be additional hurdles to gain what's termed the informed consent of children and young people to the collection of their personal information. And certainly I foreshadow, I think that is an area that may be altered going forward. So certainly a sport may have legally entirely correctly collected the personal information of an under 18 child or young person, but is it ethically okay to use it in the manner that is proposed? Has there been informed consent is another point. So for certain things, so if you were, for instance, making a particular athlete the centre of a marketing campaign and they're under 18, has there been informed consent through the parent guardian understanding the obligations, having explained them to the child or young person, and both the parent guardian and the child or young person having both agreed? Sports should also be really considerate of how they use the personal information of the under 18 members, participants, other people that come across and interact with the sport. It's probably, in our experience, quite common that sports don't have a great handle of all the various ways that information is being collected and used. And often that's because there may be 6, 7, 8 different scenarios where collection will occur, and they might be the responsibility of different people. And at the lower levels, that's almost certainly going to be volunteers in each scenario. So you get a really fragmented approach to collection by a sporting body. So one of the biggest recommendations that we have is for those types of sporting bodies to actually sit down as a collective and map out just at a high level where there's collection, because sometimes it gets to a stage where the committee or board isn't even aware of all the scenarios where there's collection occurring. So as a first step, that's absolutely critical. And then the sport can make an informed consideration of how and when it's collecting that information and how and why it wishes to use it. And then obviously, as a overarching consideration, where the club or the SSA or sporting entity is required to comply with the child safety standards, then there's the overlay of is how we're using the personal information of children and young people consistent with the standards. And when we're considering how we would show compliance with the standards, how can we show our use of personal information fits with our overarching principles, objectives, and the like. So particularly for usage of photos of children, results, etc., the sport needs to be aware of and thinking about how can we justify this under our overarching statement of being a child safe organisation, and how we say we comply with those standards. So I probably may have gone a little bit over time, but more than happy to take as many questions either now or at the end of the panel. Tom, over to you.
Thanks very much, Simon. Excellent presentation, and yeah, plenty for everyone to think about. What we might actually do is just hold off on the questions for now. There's a few questions in the Q&A, Simon, so we can either ask them later on, or potentially you can also type answers if that works as well over the next little period. I'll now introduce our next speaker, Keddie Davies, who is the Director of Sport, Recreation and Racing at the Department of Jobs, Precincts and Regions. Welcome to you, Keddie. I've got your slides up here, so I can bring that up for you. And you'll just need to get your video and mic on, and then over to you.
Thanks very much, Tom. Now, I am trying to put my video on, but it is telling me the host has turned me off. So happy if the host turns me on, but it's not allowing me to switch my video on. That might be a good thing, given I'm not looking that fresh this morning. Hi, everyone, and I might just start by acknowledging the traditional owners of the lands in which we're all respectively meeting, and pay my respects to elders past, present and emerging. Thanks very much for, thank you. Thanks very much, Tom. So I'm Keddie Davis, for those of you who I don't know, and I am just clarify that I'm not the director in sport, recreation and racing, but of participation development, which is in that group. As you all know, if you've worked with government, there's quite a few tiers, and Peter Betson is our Associate Deputy Secretary, who heads up the whole group there. So I would never want him to think or that I am anywhere near his position at the moment. But thanks very much for inviting me today to this forum, and I was really excited that my colleague Talia had asked me to be part of this and have a little reason to speak to everybody and talk about some of these really important pieces of work and standards that sit across our sector. And today I'm just covering off very briefly on the child safe and member protection priorities going forward. For government, I know there's a lot of movement in this space at the moment, and we've had the National Integrity Framework provided recently at the national level, and I think that's brought a little bit of, I understand there's been a little bit of confusion, which, you know, always makes sense with this number of tiers of government that we have working in this area, but around the MPIO role. And I just wanted to firstly say that this is a really important role and absolutely remains that going forward. There isn't a change in that area for us, and we'll absolutely continue to support the training that's provided in this area and encourage all of our sports to have an MPIO as well. We as SRV are working really closely with Sport Integrity Australia, and including Play by the Rules and our state and territory counterparts. Even, you know, understanding there's been a little bit of a change in terms of some of the governance structure at that level, but we have, at the moment, we've got our Peter Betson, who is our Associate Deputy Secretary. He's co-chairing the Play by the Rules Management Committee at the moment. So, you know, there is a real priority for this going forward, and we've got a real voice in this area. So I just wanted to reiterate that really important role, and we'll continue to support that for MPIOs, and complaints and disputes process is is something that I think, given the environment we're currently finding ourselves as COVID continues, you know, we continue to go through this cycle of lockdowns and restarts. I imagine there is a fair bit of, well, I know there's a lot of pressure on communities. The MPIO members as well would be feeling that also. So it's really important that we continue to support them. So in terms of, as well, Play by the Rules is working towards conducting a full review of the MPIO role. So, but sorry, excuse the movement here at the moment, everybody. We're all working from home and learning from home, as I imagine lots of you have as well. So that's my daughter. So in terms of Play by the Rules, working towards, you know, having that full review of MPIO role, but have been assured that the role is definitely here to stay. So I just want to assure that today, first and foremost. We're running 2 free training sessions per year, which ends up resulting in about 50 new MPIOs per year as well. So we'll continue to do that. The next training session, as some of you might know, is on the 5th of October. So that's the commitment we're making to this area, and hopefully that assures everybody of the position we have. The second item on my slide there is around the new child safe standards rollout. So from 1st of July, they have come into play, as you all know. Just wanted to confirm there's a 12-month transition period for us to move to those standards. So we'll be really working closely with, you know, the sector in communicating what that means, and we ask that SSAs ensure their affiliates are provided with this information as well. That's really important, that trickle happens for us, and that the resources provided will be released to support that transition as well over the past 12 months. So communication is really important in this area, and you'll be receiving information from us going forward. The third area that we have on the agenda there is child safeguarding policy and procedures. The new standards are coming in 2022. It's a great time at the moment, I think, for encouraging sports to review their existing policies and procedures that they have in place. And we want to just reiterate that we provide funding support for this through Together More Active funding. So we've just had that the application round for TMA, and we will be supporting some sports in that area to review their standards and policies at the moment. Sorry, not standards, but their policies and procedures in that area at the moment. And also when we open up for this year's sporting club grants, also there's a category there that you can apply, sports can apply and receive some funding support as well. So just want to remind everybody of that financial support that government can provide. Fourth is Play by the Rules. Absolutely, really fantastic resource we just wanted to remind everybody about. We've invested financially in this platform, and it's supported across Australia as well. It's always good to just remind people about that. And I think recently I did see Vic Sport had in their newsletter a little promotion about Play by the Rules as well. We have, as I said, we've got Peter Betson as the co-chair of that management committee, and we also have our own Talia McGrath, who's on the reference group and supports Victoria on that committee. So any questions or anything you need to ask or talk about, Talia's your go-to person there from Sport and Rec Victoria. This gives us, I think, us particularly having Peter Betson co-chairing, it really gives us quite a strong voice in this area, and allows us to have that additional input. the content and the resourcing, what that resource looks like. So this year's a really good opportunity for us to influence in that area quite strongly. And for those of you who worked with Peter Betson, he'll be a fabulous advocate for us as well at the table. So I just wanted to remind everybody of what's going on with SRV in this space and all these important initiatives. Thanks so much, Tom, and really appreciate that presentation from Simon as well. I learned a lot listening to him there. Thank you.
All right, thanks, Keddie, and apologies for mispronouncing your surname and getting the role title incorrect, but thanks very much for that update from our important partners at Sport and Rec Victoria.